property?
There can be, not necessarily. We have a concept of bifurcation, and so you can have a bifurcated judgment. It's not uncommon for someone to want to terminate marital status before the other issues are resolved. So if, say, somebody's filed a petition at least 6 months ago and issues aren't moving along at the pace they would like them to be, they might ask to terminate their marital status before the issues are resolved. That would be a bifurcated judgment. You may have a separate judgment then that resolves all the financial issues or some of them. Mm-hmm. So it would not be uncommon to have either one judgment that resolves everything or two or more judgments that resolve cumulatively all the issues in the dissolution of marriage.
Okay. How does the court determine whether a spouse or former spouse qualifies for spousal support?
The primary issue is need and ability to pay.
Okay.
On temporary support, they try and make it easy for the court and easier for the parties to resolve it quickly by putting out schedules. It's something like the mandatory child support guidelines that the state puts out for determining support, child support. Just like child support, spousal support is based on income. What is the income of the husband? What's the income of the wife? And then you would also look at tax factors. The tax factors usually are property taxes if people own a residence and deductible mortgage interest. And you plug that information into a computerized program, and there are several of them, and all of them would have Santa Clara County has its own set of guidelines for spousal support. When that information is put into the program, it determines an answer, and that's probably what the judge would order. And so in most cases, people are able to agree on a temporary support order based on use of the program without having to appear in front of a judge. Sometimes it's a lot more complicated when you have issues of variable income or issues of one person is allegedly working below their capacity or not working and you don't think they're sufficiently looking for a job. Then it becomes a lot more difficult to determine a temporary support order, particularly of variable income or self-employment situations. In self-employment situations, income could be all over the place. Somebody might have a tremendous income 1 month and 2 months later they might lose money. So it's more difficult, one, to determine what do you use for their income, and two, even if you can agree on what their income is, how are you going to fashion an order where there's variable income from month to month, or even more complicated, what if both parties are self-employed in different businesses and they both have variable income, and that happens, and then you've got a very complicated situation to try and come up with a support order. It's theoretically, and I've seen this before, where 1 month one spouse may be paying, husband may be paying wife, the next month wife may be paying husband because their incomes have changed from month to month.
Oh my gosh. And I was just thinking as you were talking about this, that I imagine the income actually can become more variable for people when they're going through emotional circumstances like a divorce.
Absolutely, no question about it. Especially self-employed people. What you see is people
or
that
salespeople.
People that have stable employment. A lot of employers, I think, are very sympathetic to people going through a divorce and will carry them, even though they may not be as productive during the divorce. But salespeople or self-employed people that are making money based on their production may see a significant loss of income just because emotionally they're not able to perform at the same level they otherwise would perform. And then of course the other spouse suspects they're intentionally depressing their income because of the financial issues in the divorce case. Right. And sometimes you don't know, or it may be a combination of both of them.
Yes, yeah. How is the amount of spousal support determined?
Well, when you looked at, we talked a little bit about temporary support, and that's pretty much a function of income. How much income does each spouse have, and the tax factors. When you get to permanent or judgment support, the code tells us there are some various factors the court must weigh. You start with the age of the parties, the health of the parties, education of both of the parties, their work experience, their earning capacity, their actual earnings, whether there's some disparity in their property holdings because one of them may have separate property that the other doesn't have, whether a party has stayed out of the workforce to raise minor children during the marriage. There are a few other factors relating to domestic violence. So the court's supposed to take all of these factors and consider them cumulatively and then come up with the appropriate amount and duration. One of the overriding considerations is length of the marriage, which can be very instrumental in determining the duration of support. So when we look at spousal support, unlike child support, we know it's supposed to last until the child turns 18 or 19 if they're a full-time high school student living at home. With spousal support, we don't know what the duration will be. The law tells us that 10 years is presumed to be a long marriage and that the court should not set a termination date for spousal support unless there's evidence that the supported spouse will become self-supporting by whatever date the court selects. And in some cases, that's difficult to do. Say you have a long marriage, say 20-year marriage, and the wife was a homemaker, stayed home, raised the children. The husband was the breadwinner and has a substantial income. That's a situation where it's quite possible the wife will never become self-supporting before retirement age, and you might have an order that, likely in that case, you'd have an order with no termination date other than it would state it would last until either party's death or the recipient's remarriage. In a shorter marriage, a very short marriage, the court probably should set a termination date, and people will usually negotiate a termination date. Often people will talk about half the length of the marriage. There's no absolute rule on that. There's a statute that says half the length of the marriage is presumed to be a sufficient amount of time for the supported spouse to become self-supporting, but that doesn't mean you necessarily use half the length of marriage. But I think in shorter marriages, say, up to maybe 7 or 8 years, it would not be uncommon at all for the parties to negotiate a settlement where the recipient received spousal support for something close to half the length of the marriage.
Okay. When a divorced person remarries, how do the new spouses tend to respond to spousal support obligations?
Well, when the former spouse remarries?
Okay.
When the payor remarries.
Yes, so now the payor remarries. Yeah. So wife remarries, Paris Hilton, and she's got her husband, but she's got this monthly obligation. So how do they tend to respond to this?
Well, first you need to know that spousal support orders are usually modifiable unless parties have negotiated in a non-modifiable order. So when the payor remarries, it's not unusual for the new spouse to be upset about the payments that are being made to the former spouse. And I can say over the years, a lot of times when I have people come in for a consultation, you see a man and a woman come in and you don't know their relationship right away, and you find, okay, this is the wife, so what are they doing here? It's often the new spouse bringing their spouse in to see if they can terminate or reduce the support obligation to the prior spouse. And so they usually don't feel very good about it. It's a very emotional issue.
Yeah. Okay. Does death terminate the obligation for spousal support?
Yes. In fact, almost all orders will say that the payments terminate on the death of the recipient. In fact, the Internal Revenue Code says that is one of the requirements that must be written into the court order for it to be a tax-deductible payment by the payor. So that's very important. Typically that's what orders will provide. Not that people couldn't negotiate something other than that, but I would say it's relatively rare, and that would be a standard term for terminating spousal support, death or remarriage.